Hi, my name is Mark Oettinger. I'm going to be spending the next 30 to 60 minutes or so describing the law in Vermont regarding residency as it is used to determine whether kids that are anywhere from pre-kindergarten to 12th grade have a right to attend publicly funded public schools. I was General Counsel at the Vermont Agency of Education from 2006 to 2013. Where I certainly helped conduct a lot of appeals that fall to the Agency of Education under what's called 16 VSA Section 1075, which is the residency statute, Title 16, Section 1075. I also advised and counseled superintendents and school districts and individuals at times about this area of the law. It is important because if you are a resident of a particular school district and that district has a public school at the grade that you or your children wish to attend, if you're a resident of that district, you can attend that public school. Now, where it often gets even more complicated is when you're a resident of a district or you claim to be a resident of a district that does not have a public school at the age bracket of your kids, and therefore you would have under Vermont law public school choice, or in some cases approved independent school choice as well. There are certainly some people who would like to be residents of districts that have school choice so that they can essentially have an unlimited choice of public and independent, approved independent schools. So there are some parts of the state of Vermont where this is really a problem because people sometimes represent that they are residents of a district when in fact they are not. And so the responsibility falls to school districts, and some of them it's actually the school board that conducts these residency hearings. In other cases, the school board has a policy of delegating that responsibility to the local school administration, typically the superintendent. And based on the findings of the fact finder, whether it's the school board or the superintendent, a determination then has to be made as to whether a particular family is in fact a resident of the district and therefore does qualify either to go to the school in question or to have tuition paid to a public school in another district or to an approved independent school. So how does one go about doing this? I'd also like to point out that I'm working off of an outline that is a copy of which is located on my website, which can be found at www.markoettinger.com. It's one word, MarkoEttinger.com. And if you go to the publications page on that website, there is a one-page outline that I'm going to be working off of entitled Residency Hearings, subtitled Guidance for Superintendents and School Districts. So the first question is, what is residency? Again, I mentioned Title 16, Section 1075. For those of you who have this education law handbook, I think you probably, you might want to pause the video here and actually open to that section, Section 1075, which in the edition that I have in my hand is at page 144. So residency is sometimes also defined in the law as domicile. In the case of a family, for example, that has several houses, they may have a vacation home, they may have a camp, they may have several residences or homes, first home, second home, vacation home, but they only have one domicile for purposes of public school choice and tuitioning issues. And that is their primary place that they live. Home is where the heart is. It's basically your home of homes, your primary residence. And this is what the debate is often about. I mean, you may find somebody who, let's say, lives in New Hampshire, but has a place of abode in St. Johnsbury, Vermont, claims to be a St. Johnsbury resident, and therefore, since St. Johnsbury does not have a public high school, they have school choice at 9 through 12. And you may find a family suggesting that they're asking the St. Johnsbury School District to publicly tuition their child or children to the St. Johnsbury Academy, which is an approved independent school. So if this family has an apartment in St. Johnsbury and a primary residence in Littleton, New Hampshire, for example, you get into situations where the school administration might doubt whether the claimed residency in St. Johnsbury is in fact the domicile of that family, or if it's simply a second home, because second homes do not equal domicile. And in a case like that, maybe the family, if they're domiciled in Littleton, New Hampshire, may have some type of school choice options, but that would be a question of New Hampshire law, and this conversation is focused on Vermont law. So first thing to keep in mind is that residency, as we are going to be talking about it, is really, we should use the term domicile. The case law. There are a number of cases in which the Vermont Supreme Court has had disputes before it, where it has had to determine what the domicile of a particular family is, and they have applied 16 VSA section 1075, and they have concluded that it is a fact-finding exercise, and that the question of where you are domiciled is really a totality of circumstances analysis. There is no litmus test. It's not just where you spend the most of your nights, although that's certainly a factor. Things such as homestead declaration. In Vermont, there's a differential homestead tax rate, and so you don't get that differential rate for anything but your primary residence. So that's a fairly strong indicator. If you claim that your primary residence is in a particular location, that's pretty strong evidence that that's your domicile. So what else? What about on your tax returns? You file a federal tax return, they ask you what state you're domiciled in and what town. You file your Vermont income taxes, presumably if you are a Vermont resident. So in the fact pattern that we've talked about, if the family in question files state income taxes in New Hampshire or claims to be a New Hampshire resident, they don't have a state personal income tax, but does not file a Vermont income tax return, that would be some pretty strong evidence that they're not Vermont residents. Where they register to vote, where they have, let's say, their bank accounts, where they go to church, the driver's license, the address on the driver's license, whether they have a Vermont driver's license or a New Hampshire driver's license. All of these types of considerations would be relevant, and many more. I've seen cases in which utility bills have been examined to determine, for example, whether power usage would indicate that a family is in fact in the town that they claim to be a primary residence of. I've seen residency hearings in which people have testified that the driveway during long stretches of the winter is not plowed, or that the lights are not on at night. So those are the kind of fact-heavy determinations that are going to go into determining whether somebody is a resident for tuitioning purposes. So I would recommend that if you have a question, if a superintendent or a school district has a question about the legitimacy of a family's claim to residency, that you develop a set of forms, and you probably, the first time that anybody arrives in your school district claiming to be a resident, they should fill out the form. You should ask a long list of questions. I know that various districts have residency forms. It's always been my feeling that the Superintendent's Association or the Principals Association or the School Boards Association might want to think about posting a sample residency form. Perhaps they have. And I would recommend to the viewers that you take a look at the websites of the Vermont Superintendents Association and the School Boards Association, because they have a wonderful compilation of forms there. A lot of great resources. So one of the questions you have to ask yourself is, how formal of a hearing process do you want to afford the families at the local level? Do you want to have something that looks a lot like a trial? I'll tell you that when the Agency of Education conducts its appeal hearings, we do often handle those, or we did during my tenure there, we did often handle those in the courthouse. The court clerks, we found, were quite amenable to the idea of giving school districts the opportunity to use space when that part of the courthouse was not used or necessary for another purpose. And I would strongly encourage school administrators to use a neutral setting. There is a practice in some locations that these kind of determinations are made at the office of the superintendent. And I can just say, from the standpoint of the parent's perspective, that seems often seems to the parents to be kind of almost prejudging the determination, the outcome. So I would encourage, whether it's a library, public building of some sort, some kind of a neutral capacity, because I think that invests the situation with a greater sense of independence and fairness. I guess it would be my recommendation that school boards not try and take these kinds of cases on themselves as a normal course of events, but rather have the superintendent or somebody in the superintendent's office actually do these screenings. I do think that the school board ultimately has the responsibility for, if the parents are dissatisfied with the administration's decision, the school board does have a duty to look over the determination and to decide, whether in fact it was supported by, reasonable evidence, and that a proper due process type of opportunity was had by the parents. Keeping in mind that under Section 1075, the parents do have a right of appeal to the Agency of Education if they are dissatisfied with the decision at the local level. What we always used to tell parents is that they have to make sure that they had something from which to appeal, whether it was minutes of a school board meeting at which it was clear that the residency question was taken up, facts were found, conclusions were drawn, and in this case it was decided that the parents in fact were not domiciled in the district. The other thing that in some districts we would find is that there would be a separate decision, sort of a slightly more quasi-judicial kind of a document. That independent decision would then essentially indicate what facts were found and why those facts, it was felt, under 16 VSA Section 1075, failed to establish the necessary criteria for residency. A written decision of that sort doesn't need to be excessively detailed, but it should be sufficient. When the appeals are taken to the Agency of Education, at least during my time there, we would basically start over. There were some districts that sent us paperwork, for example, tax returns, leases, phone bills, things like that, that had been used at the local level, but that was the exception as opposed to the rule. And we would pretty much conduct hearings that would run anywhere from, say, 2 hours to a full day, depending on the complexity. Witnesses would be taken, documents would be received, and then eventually a recommendation would be drawn up by somebody from the legal office in the Agency of Education, and that would be reviewed by the Secretary of Education and eventually issued as a decision of the Secretary. Now, at that level, of course, it can be further appealed to court, but those types of circumstances would be very, very rare, but they're not completely unheard of, and that's why the Vermont Supreme Court has made rulings that we can look to in terms of trying to understand what domicile really means under Vermont law. And that's where we get our idea of the totality of circumstances test. So under Section 1075, if an appeal is taken from a local school board, the Secretary is obligated to order the child or children to be enrolled pending the appeal. So the thing that the law does not want to see happen is that the child's public education is somehow interrupted. So chances are that if the child has been enrolled in the first instance in the school, either at the newly so, or perhaps has been a resident or been believed to have been a resident for some time, and suddenly questions have been brought to the forefront, perhaps by other concerned citizens, people that think that a family is obtaining public tuition under circumstances in which they should not. But so experience shows us that the secretary will generally order that the child be enrolled at the local public school where they are either have been enrolled so that there's continuity of education. This is pending appeal, or that if the family makes any type of a credible prima facie case, we would call it, of residency in a domicile, that is, in a particular place where they have asked the school board for a ruling and where the school board has said no. Under those circumstances, chances are that the secretary will order the child enrolled in that district. Again, pending appeal. So how long does the appeal take? Well, it depends a little bit on what the backlog of cases is. I would say you can expect the process to take 30 to 90 days, depending. And what does that process look like? Well, initially, a hearing officer is designated by the secretary, typically somebody in the legal office in the Agency of Education, but it could be an independent hearing officer. They then would conduct what we call a telephone status conference. Some of these cases, most of the cases, I'd say the parents are not represented by attorneys, but they certainly have the right to be. In most of the cases, maybe more than 50%, but not all, the local administration, the school administration, is represented by an attorney. So if you have the most common situation where you have no attorney for the parents but an attorney for the school administration, my experience is that the hearing officer wants to be very sure that the playing field, if you will, is balanced. So very quickly after the appeal has been filed and the document, whether it's minutes or whether it's a written decision from the lower tribunal, if you will, from the school board, once those documents have all been received, the hearing officer convenes a phone meeting with the attorneys, or in the absence of attorneys, with the school district and with the parents, and sets a schedule that's going to lead up to that hearing. That schedule would typically require the parties to submit paperwork, and each party could ask of the other party, typically the school district would ask of the parents, to submit things like tax returns, copy of a lease, copy of a house deed, proof of voter registration, things like that, and in advance of the hearing, so that the school district can assess those documents. Because there are times, admittedly, when parents are sometimes reluctant to produce these types of documents for privacy reasons, which are legitimate, but the hearing officer can also order that certain documents not be turned over, or if they are to be turned over, that they be redacted. In other words, edited with private information removed, so that things like income tax amounts don't have to be disclosed, while at the same time your claim of residency, the fact that you did or did not file a Vermont income tax return, would be available and fair game. So in any case, at that early telephone conference, the hearing officer would set times for the submission of documents, would make a ruling as to whether the documents that the superintendent or the school board wish to have disclosed, whether they should in fact be disclosed, and then a date would be set for the hearing. It would also be determined at that point what sort of level of complexity the hearing would have, what degree of formality, which again is going to depend upon the circumstances of the particular case. And it could be something that the hearing officer feels comfortable resolving just with a submission of documents, but without the need of people appearing in a courthouse or in a public facility in order to give testimony and be cross-examined. And again, it's up to the hearing officer to make a determination as to how much process really is warranted in the particular case. So in the more complicated cases, you can expect that the parties would testify. The hearing officer would generally place the parties under oath, which would mean that if they were to testify falsely, they could be subjected to the types of penalties that would attend false swearing or perjury. It's very, very important that the evidence that is introduced be truthful and accurate. And so it's for that reason that some degree of formality is going to be appropriate in any of these cases. Aside from the fact that individuals will be asked to testify or have the opportunity to testify, they also can be cross-examined, which means that an opposing party can essentially put, let's say the school district can put a parent on the stand and say, tell me about your job. Isn't it true that you work out of state? Isn't it true that last month you were only here on weekends? And perhaps a school board could, or the superintendent or their attorney could confront a particular parent with a electricity bill showing, or a phone bill showing that the house phone at the house at which they purport to have been residing during the school year, that phone calls are only during Christmas vacation and on an occasional weekend, implying that that the house is being used for vacation and second home purposes and not as a primary residence. Individuals, for example, who work at the school, who might have driven by the house, who could testify about things like lights not being on, driveways not being plowed, things of that nature, comments that might have been said offhandedly to a third party that would either support one side's case or the other. Any of that kind of evidence could be introduced. As I said, since these are factual determinations and since the facts of these kind of cases vary as much as they do, it's really hard to draw any general conclusions about what these hearings look like. They vary, as I said. Maybe no hearing at all, maybe just on the papers, maybe a couple of hours, maybe a full day. I've never seen one go longer than one day. So another question that you might confront is, so should a record be kept? In other words, should you record the testimony? And at the state level, if the appeal comes from the local school district to the state, the answer is yes. At least it's going to be recorded by tape recording device or digital recording device, so that if there is an appeal, the parties have a right to a transcript. A transcript generally doesn't get produced unless it is needed for a further appeal, which is rare. But you have to have the ability to produce one in case it's necessary. I've seen a case or two in which there actually has been a court reporter present to stenographically take down the testimony. That seems to me to be perhaps a bit over the top. It's expensive. It adds additional complexity and time to the hearing. But again, if either party wants it to be recorded, they're free to do that. And sometimes the hearing officer will decide on his or her own initiative that there needs to be a formal recording. Ultimately, the decision of the Secretary of Education when there's an appeal to the state level will be in writing. It may be fairly lengthy. It may come out anywhere from a couple of days after the actual taking of evidence to a couple of months. But in the meantime, as long as this order of continuing enrollment is in place, the education of the children are not disrupted. Keep in mind, if the determination is that no, the kids are really not residents of the district in question, then that means that those kids are either going to have to get relocated or the parents are going to have to start paying private tuition. One of the things that sometimes comes up is the question of whether at the state hearing level, whether there could be a determination that the parents owe money to the school for the period of time that it's been determined that the kids were not resident. We have generally held that it is not the function of this process, the administrative process, to issue judgments, monetary judgments. Plus, it generally would not be the case that the hearing officer would concern him or herself with past history. They would simply make conclusions about whether or not the kids are domiciled, the family's domiciled within the district today. and prospectively, and on that basis would simply make the ruling yes or no as to domicile, and would not concern themselves with the question of whether there should be a judgment issued for a back tuition. Now, keeping in mind that there is a significant amount of money involved here, if you look at the cost of educating kids on a per child basis, the state average in 2014 is somewhere in the $13,000 range. There are some schools, we used St. Johnsbury Academy as an example, where the tuition rate is closer to $18,000. And there are a couple of schools in the central Vermont area, over in the Upper Valley area, with tuitions of $18,000 or I think even $20,000. So when you do have a case where you have a family that has multiple kids involved, on an annualized basis, we could be talking about over $50,000 per year. So it's a substantial amount of money, and so the stakes are high, and that is why there will be cases in which school districts will invest significant amounts of money in attorney's fees in order to be represented on these issues. Now, that's especially true in some of the sort of higher traffic districts where they have the combination of school choice and proximity to what are perceived to be really good schools. And let's make no bones about it, St. Johnsbury would be an example, Burr and Burton would be another example. Thetford Academy, Linden Institute, any of these relatively large schools are approved independent schools, and they are surrounded by a number of districts that have school choice. So those are going to be the parts of the state where the incidence of residency appeals will be greater. So I think maybe we should leave it at that for today. If you're interested in taking a look at the outline, it's on my website. You have that URL. There's also a sample residency decision on the publications page of that website. And if you have any questions you'd like to follow up with me, whether you're a parent, whether you're a superintendent, whether you're a school board, feel free to do that, and I will answer the questions as best that I can. So thanks for tuning in, and I hope this has been helpful. Take care.